Of Busia, Senator Okiya Mtata. Good evening, gentlemen. And let's begin by appreciating, because now we have a judgment of the Supreme Court, and it's been a journey, because it started off in November last year when the High Court decided and told us that there are sections of the Finance Act of 2023 that were unconstitutional, null and void, but that only touched about 3 acts. We're talking about the Kenya Roads Act, Unclaimed Assets Act, and Statutory Instruments Act, but also the question of the housing levy at that time. At the Court of Appeal, found the act in its entirety to be unconstitutional, therefore null and void. The Supreme Court has overturned that and appears to suggest that only the areas that the High Court had found to be unconstitutional are unconstitutional. What is your first impression of this, Senior Counsel?
Let me add that also there was a provision on Statutory Instruments Act that the High Court had found to be unconstitutional. This one has also been clawed back by the Supreme Court. So the first impression I have is that the Supreme Court has clawed back substantially on what you could call the progressive jurisprudence of the High Court and the Court of Appeal on the question of public participation and the need to give reasons, on the question of not introducing substantive provisions in a bill after it has undergone public participation. And there are a few such areas. But I would also say that the other time we had a very high-profile litigation going from the High Court to the Supreme Court, the Building Bridges Initiative litigation, something similar happened. There were very progressive findings in the High Court, many of which were upheld in the Court of Appeal. And when we reached the Supreme Court, again, they clawed back a big part of those progressive findings. So I think the Supreme Court has found that one of the roles that it is performing is to kind of like conserve, to be more conservative by preserving previous legal arrangements, taking into account maybe political aspects that tend to go along with constitutional litigation in a way that the High Court and the Court of Appeal do not do. So to the observer, it looks like, and it indeed is, some form of clawing back on some of that progress in this litigation.
What do you mean with political aspects that go with litigation?
So constitutional litigation world over has certain political implications. For example, the BBI bill had a lot of political implications relating to the arrangements between the coalitions that were in existence at the time. The same thing happens with the finance bill, with the current proceedings involving the deputy president in the High Court. And you'll find that in countries which have a Supreme Court, it is designed to have judges who have maybe different background. Sometimes they have a varying philosophy. And the idea is that when they come together as a body, it's not a single judge, it's not a bench of 3 judges, it's a bench of many judges, that they will take into account considerations that may have political aspects, or of different parts of you could say, the equation or the ecosystem. However, the decisions of the Supreme Court are still meant to be based on facts and the law. It's only that when you're interpreting the Constitution, you can interpret the Constitution a bit more progressively, a bit more conservatively. And there are some people who don't like that terminology about progressive and conservative. They like to use a different terminology. I think what I'm saying is that the Constitution has within it provisions that say it is always speaking, interpret it in a transformative way, and it also has provisions that talk about culture, that talk about history. The Supreme Court Act actually says that when the Supreme Court interprets the Constitution, they should consider all these issues, including the history of the people of Kenya, economic interests, and so on. So the Supreme Court doesn't consider things that you could call purely legal. The Supreme Court Act itself tells them to consider other surrounding factors, whether it's economic, cultural, and so on, historical. Okay. So they are doing that one, and the end product tends to largely disappoint those who push for progressive findings of the court.
All right, and of course it's binding on all the other courts that are below it, isn't it?
Yes, a decision of the Supreme Court, once it is made, it is binding on all other courts. The essential decision, not every statement made by the Supreme Court is binding.
Okay.
In law, we distinguish between the reasoning of the decision, that is what is binding, and we distinguish that from what we call other comments or comments by the way. So comments by the way are not binding.
Okay.
What is binding is the reasoning that leads to the particular orders that were issued. Okay.
Senator, what's your take on this? Because you've been very active all the way from the High Court. You had some win at the High Court. You got a great win, a big win at the Court of Appeal. Now it appears everything is lost. Is that how you feel?
First of all, it's nice to be with Charles.
Yeah.
My long-time friend. I've done so much together, but we have not been on the set together in a while.
Right.
Have we ever been on a set together?
On a panel? I don't remember. This may be the first.
Oh, okay. Good stuff. New beginnings, maybe?
Yeah, so...
What's your take on the decision?
Well, the decision is difficult to comprehend because it's like it was written by, I don't know, with a preset mind to try and realize some outcome because the reasoning that is given is in many places the reasoning somehow peters out somewhere. I've been trying to read and understand it. And so I find it really sad. It also avoided issues. Like if I go to paragraph 76.
Right.
The judges raise a very important issue, which concerns interpretation of Article 110, I think, clause 2 and clause 3 and clause 5, I think. But one clause says, a bill not concerning county governments shall be considered only in the National Assembly. Then clause 5 says, a money bill shall be introduced only in the National Assembly.
Right.
Now, there's been a practice in the National Assembly that the word introduced only means it shall be considered only. Some of us have argued that it being introduced means where the journey originates. Because any other bill can originate anywhere. Yeah. But this particular bill, the money bill, they say has to originate from the National Assembly. And the question has been, does the use of the word it shall be introduced in the National Assembly mean it shall only be considered in the National Assembly? When in the same article, it has been put up that the what do you call it? A bill not concerning county governments shall be considered only in the National Assembly. So there's been a major fight between the two houses. So after capturing that, the court just drops it. Doesn't go further to interpret it, and then goes at a tangent and makes other findings. There's the question of revenue estimates that come to Parliament. What happens to them? Do they just disappear? And the court has argued that they are not required to be in the
Appropriations Bill.
In the Appropriations Act. But then where do they go? He said they've been presented in Parliament. And when you go to Article 109, Clause 1, it is very clear that Parliament expresses itself through bills.
Right.
Legislative power of Parliament. Through bills approved by Parliament and assented to by the President. Where does the Supreme Court then place these estimates for them to be part of the budget? Because a budget is an act of Parliament, is a law. It's an act of Parliament. Right. So when we have budgets that don't disclose revenue, we're not having the full budgets. It captures very well Article 220, the composition of a budget. Then it goes into some, what I would call abracadabra arguments, and arrives at a conclusion that the estimates of revenue do not have to be there. Then why is this, how do they become part of the budget? If they are not in an act of parliament, how do they become part of the budget?
Right.
So these are the questions we have, and you see, it's not an idle question. It has been a major problem through which public money has been lost. If you look at the budget parliament approves, even in the Appropriation Act the way it is, the budget it approves contains all the loans to be borrowed and grants. But nowhere does it contain any domestic borrowing. Then when you come and you find every month, the Minister for Finance publishes what they call a statement of net revenue, actual revenue and net expenditure. Now when you look there, they produce revenue estimates that include domestic borrowing, that include loans that are not even in the budget parliament approved. And it is this thing of hiding the revenue side of things that has led to a lot of corruption. So that you find that all the what you call it, all the IMF loans today that are giving us trouble, all the domestic borrowings have not been approved by Parliament.
Right.
So, and the whole thing is that they are not in the Appropriation Acts. So when the Parliament is not allowed to continue this habit of not producing revenue estimates in the budget, because the Appropriation Act is the budget. There's no other act.
So really, because you are there, what is it that happened?
I raised this issue, and then the courts asked me something very strange.
Yeah.
That what has been happening before. That's a question I would expect in Parliament, not in a court of law. What has been happening before is that the law has been violated.
Right.
So the courts are not ready to interfere with what has been happening before.
All right. And of course, the viewer can join this conversation.
And then there was a very important thing.
Just hold on. You can join the conversation by writing to us at Citizen TV Kenya, that is on X. The hashtag to use is Citizen Explainer, and I will be sure to raise some of those questions that you may have with us. You wanted to say something before I can move?
Yes, I wanted to say something. There was this article 249, clause 3 of the Constitution, which very clearly states that the Parliament should ensure that commissions and independent offices are properly funded. Now, when you exclude the Senate from the budget-making process, how does Parliament ensure that? This is like Anti-Corruption Commission. That's what? Oversights counties. The Auditor General audits counties. Control of budget approves budgets of counties. So there are bodies that do what? That are concerned about counties. Now, when the National Police deals even with counties. Now, when you go to the budget-making process under Article 221, even the budget of the Parliament itself, which includes the Senate which oversights counties, is passed there. So how can one house be passing these budgets when the Constitution is very clear that these budgets should be passed by? Now that one, the court does not even mention it. It avoids it like the plague. And it avoids it because it wants to arrive at a certain conclusion, because this was a death blow to the whole case. Right. So the court avoids it deliberately. In fact, when if you search under Article 249, for some act of faith, it comes up to 249, but 249 is why they give the orders as a number of the paragraphs. Right. So the court, I think, had a mindset, and it went ahead to achieve that mindset by meandering around and making some very elastic arguments.
All right.
That's how I would look at it.
Senior Counsel, so the argument or the reasoning of the Court of Appeal, rather, was quite heavy on the question of public participation, that it was crucial, even talking about accountability, that when Parliament, before enacting the bill, comes back from public participation and makes certain changes, they owe it to the people to at least explain what happened to the views of the people. And this has been on one issue that bills have stood or collapsed when you go to the courts. What does this mean moving forward for public participation?
What the Supreme Court has said is, one, that there should be a bill that should be passed into law to clarify how public participation is done. Secondly, the court has reversed the finding of the Court of Appeal. The Court of Appeal had said that one of the ways of ensuring that there is a public participation is to have a clear responsibility on the government agency to demonstrate that it has considered those views. The Supreme Court has said that that question of you have to show you considered the views and even report about it, that is found in Article 47 of the Constitution. It is an element of what is called fair administrative action. The Supreme Court has gone on to argue or to find that when Parliament is exercising legislative power, that is not administrative action. That is legislative. So they've distinguished administrative action from legislative. And they've therefore said, and this is their finding, that a Parliament doesn't have an obligation to account for the various comments or views that have been received from the people. They just need to put in place a reasonable mechanism to consider the views. They don't need to account for those views. So what we had already started seeing, for example, in the report on the Finance Bill of 2024, if you look at it, you will find that Parliament, the National Assembly, has listed the various views received on what kind of issues and what was their response. So the Supreme Court is basically saying that is not necessary anymore. Because this was a finding in the 2023 Finance Bill litigation that the National Assembly then tried in 2024 to comply with. And the Supreme Court is saying, no, you don't need to go into that detail. We will not hold you to account as representatives of the people on how you vote based on a standard of public participation. In other words, we'll not say 80% of Kenyans said this, or there are 3 Kenyans who made this comment. Did you consider it? We just want you to show that you have a mechanism of public participation. The rest is up to your discretion. So definitely there is a bit of a retreat from the advance of the Court of Appeal on the question of public participation. I would also say that there is even a retreat from the High Court decision, because you see the High Court said that public participation is so important that you cannot introduce substantive changes that were not in the original bill that was subjected to public participation. What the Supreme Court has said is that processes of budget, including finance bill, are time constrained, and it is impractical to ask for fresh public participation. So that if an idea arises from public participation, you don't need to go back to it. So let me put it this way, Sam. If in the course of discussing finance bill, I, Charles Kanjama, make a proposal to Parliament and tell them, please don't tax lawyers anymore, we are overtaxed, and Parliament decides to introduce a provision not to tax lawyers because we are overtaxed, and they say that this provision was not in the original bill, but it came from public participation, there will be no test of saying, did you allow other members of the public to consider this issue? So you see, a comment may have been made by one person in public participation that is very substantive, introduces a change. This, the High Court said you can't do. The Supreme Court has said it is possible, because if a comment comes from public participation, according to the Supreme Court, then you can implement it without going back to the people again.
Correct. And Senator, so what do people do? Because for a long time, it's been, the country has been at the mercy, or Kenyans have been at the mercy of the judiciary. If you have such a decision, how then do you do it? Because for the Finance Bill 2024, you know what happened. Rejection on the streets, eventually it was withdrawn. Is that the route, or should we still have the faith in the courts?
It's a dicey question, because reading this judgment, there was a question whereby whether you can challenge policy decisions in the courts. They said you cannot. the Court of Appeal had come out very clearly that policy decisions among the issues of anything that is done under the color of the Constitution. So if you cannot then go to the courts on policy, and if your public participation in processes is cosmetic, and something bad is being done, what is the Supreme Court telling Kenyans? It's telling Kenyans that what the Gen Zs did when they stormed Parliament is the way forward. That's why some of us are resisting. The way forward should be going to the court and challenging these things, not taking the law and dealing with it the way it was done. But now look at the result. The Gen Z action on the streets bore a permanent result. My action in the courts has been frustrated. So basically, what's the way forward? The way forward is to go back to the 2020, when was it, 2007, when people chopped each other in this country because there was a dispute.
I'm sure you're not advocating for that.
No, I'm not advocating for that. I'm interpreting the ruling of the court. The court is advocating for that. Because when you choose to drop heavy issues so that you can arrive at a decision, the question of Article 249, Clause 3, I argued it. It's not even mentioned anywhere in the proceeding. It's not even mentioned. It was just like it never existed. You see, I raised 249, Clause 3. And to me, it was a trump card.
Right.
But because it was going to destroy this judgment, the Supreme Court decided not even to mention it, so that it could arrive at this judgment where it saves the Finance Bill 2003, and that also gives the executive.
Right.
It removes a major check on the executive, so the executive has a more free hand to do as it wishes, because it knows you can win in all these lower courts, but up there, there may be...
Maybe able to persuade the judges better.
Maybe they're able to persuade the judges better, or I don't know. But it's really, as the Land Council has said, it's a major clawback on the jurisprudence of this country.
Okay.
And also it's a very disjointed judgment. Looks like it was written by different schools. It's like reading the Old Testament, written by different schools. But ultimately, I would really appreciate for a Supreme Court that each judge writes a judgment.
Okay.
This idea that the Supreme Court lumps together a judgment and writes it like it was a single judge is a bit bad for us. I wish each judge was writing his own judgment so that we can be able to see their philosophy, their arguments, and whatever. Then even a concurrence.
Okay.
But this idea that the Supreme Court is a choir is a bit...
That's an interesting point that you raised.
It's a bit frustrating for me.
I just wanted to remind the viewer what is contained in the Finance Act 2023. It is the act that introduced electronic tax invoice management system, that is e-TIMS. There's VAT changes, especially VAT on fuel that was raised from 8% to 16%. There was the new pay-as-you-earn tax bans, the introduction of the 32.5% and the 35% for persons earning more than $500,000 shillings. There are a few excess duty changes. Petroleum products, what I indicated there, rising from 8% to 16% of VAT. Zero-rated LPG, or LPG was zero-rated, down from 8%. There was zero-rated electric motorcycles and bicycles, zero-rated solar and lithium-ion batteries, zero-rated electric buses. There was introduction of excess duty on imports. On fish, it is 10%. On imported sugar, it's 5 shillings per kilo. The reasoning that was given by the then Cabinet Secretary was that sugar was causing diabetes in the country. Cement, 10% of value, or 1 Kenya shillings 1 per kg, 1.5 per kg. Furniture, 30%. Cellular phones, 10%. Paints and varnishes, 15% of excess duty. Wakili, help us here. we had been seeing, including presidential petitions, you'd find judges dissenting at the Supreme Court. You'd find at the Court of Appeal and even at the High Court dissenting opinions or concurring
yes,
decisions. What's happening? Because lately, what you are seeing, even the recent decision on the Affordable Housing Act, it is, I mean, one unanimous decision by the bench. What's going on?
Okay, so Sam, let me say that the courts still do both. They occasionally have dissents or concurring opinions, and then they also have the joint decisions. When you compare different countries, you'll find that in the United Kingdom, their Supreme Court, or in the United States, their Supreme Court, the judges of their apex court tend to write more individual decisions. Those are what we call individual decisions. And that is what Omtata is saying, that the individual decision helps you to determine what is the reasoning of a particular judge. And that is very useful for litigants, because when you go before the court, you are able to address each judge based on their track record or the reasoning they've had in different cases. When the judges always make decisions en banc and none of them distinguishes from the other, then you can't tell whether a certain argument is persuading one judge or not another judge. And there has been some criticism among legal circles of the Supreme Court that their decisions are not always consistent. There are times when they may make decisions that seem to depart from an earlier precedent. When this happens in other countries, because it happens in any country that sometimes the Supreme Court departs from previous decisions, they are confident enough to say, we have set aside or we've overturned or we've distinguished this particular decision and made it narrow in application. Now we are going to a new way of doing things. But what has tended to happen with the Supreme Court is that when they change their way of thinking, they don't expressly depart from a previous decision. So if you are a litigant, you might find there are these 1,000 decisions of the Supreme Court. There was this one that was decided maybe in 2018 in a certain way. And now we're in 2024. Maybe the decision, the approach has changed a bit, but there's been no explanation that we have changed the approach. And so that is one of the criticisms that has been issued.
Right.
But to answer your question, when you are, say, 5 judges and you agree on the outcome, you may find it is a lot of work for each of you to write your individual decision. So it is an issue of convenience that the judges find it easier to coordinate in one decision when they've agreed to the outcome. And also you can distribute work. Maybe you will do part 1 of the decision, you will do part 2, I'll do part 3. But when each of you has to write your own decision, it is more work. So I actually think the main reason why the judges tend to prefer en banc decision as opposed to individual decision is that it is more efficient for them. They have a big backlog or cases to write decisions, and they find it's easier when they combine their effort as opposed to everyone writing.
Is it always a good thing, or it's...
No, it's not always a good thing. I found in the earlier years, there were more individual decisions, either concurring or dissenting, even in our Supreme Court of Kenya. In the first 5 years, I found more of that. For example, our first Chief Justice, Willy Mutunga, put a lot of effort into writing a few individual decisions. Even one of our current Supreme Court judges, Njoki Ndung'u, was doing much more individual decisions, either to concur on a certain point or to dissent on a certain point. Sometimes when the judges always agree, you can end up having what you call groupthink. And groupthink is never a good thing, whether you're in a board or you're in a Supreme Court. Groupthink is where you all think alike, because the question becomes, if you always think alike, then we just give one of you the job, because why have 7 of you if you always agree, whether it's in a board or it's in a Supreme Court. That's why it is good at times to see some concurring, where you come to the same decision but using a different route, or dissenting, where you may agree with part of the decision but disagree with part of it. And what we have found in the development of jurisprudence is that a powerful concurring opinion or dissenting opinion may in future become the majority position because you've explained it so well.
Okay.
The majority disagreed with you today, but in future they say, yes, actually, there was a good point.
Okay.
But when you're always agreeing, then you lose that opportunity to have diversity of thought in the dialogue. The dialogue is only internal. Only the judges know how they dialogued, but the rest of the people don't know how they arrived at the consensus.
All right. And of course, you can raise your questions. I want to take a look at what has come in at Citizen TV Kenya. At Sam Gichuku, the hashtag to use is Citizen Explainer. Now that the Supreme Court, this is on Songo, you're saying that now that the Supreme Court has made their ruling and they do not want to interfere with the illegalities that have been happening before, this means they have already set precedents. What can we do now that we can't appeal this anywhere as this court is final? I don't know if you want to respond to that particularly, knowing that you had also said a few things a few minutes ago.
Personally, I think that, one, this constitution is new, not just to me and Charles, who even engaged it together very well before it was enacted, but it is also new to the judges. And one of the things some of us have been agitating for, and one of the things I've had very heavy discussions with the former Chief Justice, William Mutunga, and especially on the technical sections of the Constitution, which are not purely issues of law, like the issue on public finance.
Right.
When you look at it, and the other was the issue on elections, where I've had discussions, even the former Chief Justice has had to accept that really they did not see that perspective. So the committee of experts, for me, should not have been disbanded. It should have gone ahead to give some training on how to interpret this constitution. And that training should have even go to the judges, because we really make a lot of assumptions that they know. And having started to say, a former Chief Justice and gone through it with technical people on aspects and to see how the judges have missed out on various things, that's something I could have done, and maybe something that needs to be done so that our judges are taken back to the class and are walked through this so that they can give the people of Kenya the promise of this constitution.
Right.
They should not deny us. Now, on the way forward, I think it's become much more of a political issue now. It's become more of a political issue. The judiciary has washed its hands. I know that there are people who are, I've got phone calls from people who are saying they want to go and salamia the judiciary. I don't know, but I'm saying that I was telling them that should not happen. That people who are so aggrieved, saying they want to go, they need to go and they do salamia, what they did to Parliament. They need to go and salamia the Supreme Court, those kind of feelings, and that should really give the pain with which the Kenyans have received this particular judgment.
Right.
But I think the best thing is for me going forward is for Parliament to relook at some of the acts that I've made in terms of operationalizing sections, especially the powers of issues like public participation. Parliament needs to come up with a clear law on public participation, and whether it is worth the effort or it is not worth the effort, or we leave it out. Number two, I had a senior lawyer called me and asked him a question, saying he has been toying with some problem, and he was saying, let us look at Article 10. If you look at the three aspects, it says these values bind anybody who interprets and applies the Constitution. And then the other one is who enacts law and who implements the Constitution. So we're saying who implements policy. So this guy was saying these are the three arms of Parliament being addressed: the judiciary, interprets and applies.
Government, you mean?
The three arms of government. The legislature interprets, and the executive implements.
Right.
Now, the legislature and the executive have been subjecting themselves to public participation.
Right.
The judiciary has not obeyed Article 10. It has never been subjected to public participation. How do we get a formula whereby the judiciary is subjected to public participation? That's a question that came from a very senior lawyer who called me today, thinking that this is a particular case whereby the judiciary required to be subjected to public participation.
Interesting that Rachel said that. But Charles, as we begin to wind up, the Supreme Court is also giving a criteria that ought to be to guide a court in determining whether to issue a suspension or of declaration, a suspension
invalidity.
Yes, is as follows. Very prescriptive, really. But what does that mean? Because they're also talking about whether more injustice would flow from the legal vacuum created by rendering the statute invalid with immediate effect than would be the case if the measure were kept functional pending rectification. Is it introducing a sense of guilt conscience to the courts, or what does this mean if really something is to be found to be unconstitutional? And for sure it is. Yeah,
let me give the arguments that were made on both sides. On the side of the respondents in the Supreme Court, who were the petitioners in the High Court and the interested parties who supported the overthrow of the finance bill, their argument was that the moment the court finds that a law is unconstitutional, Article 2 of the Constitution says that anything that is inconsistent with the Constitution is null and void to the extent of the inconsistency. You can't breathe life into a corpse. It's dead. And that was therefore the argument that once you find unconstitutionality, just strike it out.
Right.
Strike it off and Parliament will come up with a new law.
Yep.
There was the argument of the petitioners in the Supreme Court who were respondents in the High Court. Then they became the appellants in the Supreme Court. And then they were saying that the court should take into account public interest considerations. In a certain decision that the Supreme Court issued a year or two ago, they upheld a concept, what we call structural interdict, which is where the court issues a final decision and then supervises implementation of the final decision in constitutional matters. So they were arguing that if the court finds there is invalidity in a provision of the Constitution, instead of, a provision of law, of an act of Parliament, instead of the court declaring it null and void, give guidelines so that the legislature can amend those provisions, they can redo what they need to redo. So they were arguing in favor of a gradual process that doesn't create a vacuum or a gap. So what the Supreme Court has done is that it has accepted this argument of the appellants in the Supreme Court, that matters of striking down acts of Parliament are quite drastic, and they should be something that you do at the last consequence. And once you strike it down, if you decide to declare invalidity, you can consider suspending. So this is a new device that they have now recommended for the High Court and Court of Appeal. You can suspend the declaration of invalidity and give Parliament or give the executive, as the case may be, time to correct that mess they did in giving rise to that invalid and unconstitutional action. That's what they've now explained. What are the criteria to be used in determining how to suspend, for how long? Is it 3 months? Is it 6 months? Is it 12 months?
And that also is binding?
That part of the decision is binding because it is part of the final disposition or orders of the court. So that one is binding. And let me also say that it's not the first time that the Supreme Court, in making a decision, has been prescriptive and given a decision that not only applies to the dispute before them, but also explains procedures or processes that will apply to disputes of that kind. I think the Supreme Court understands as an apex court or the final court, it can go beyond resolving a particular case to also give directions, which is what they have done on the matter in issue.
All right. And Senator, for you, the final question here. This Fred Machoka is asking, he wants to understand why all taxes from a percentage of 100. For instance, after paying your pay-as-you-earn from 100%, the government again comes for the Social Health Insurance Fund at 2.75% of the total. And again, it goes for the housing levy, 1.5% of the total.
I think, in fact, that's a discussion I just had this evening by members of the various unions who came to my office to visit me, and they were very concerned that that particular section amounts to double taxation, that are going to be taxed or not, that have already been taxed on. So it really doesn't make good law in terms of tax law. That cannot be that after you have tax, it still remains 100% all the time. There should be a way of graduating these taxes so that if you have been taxed on something, you're not taxed again the same. Like they pay as you earn. It's taxed on the gross. Now you are getting housing on the gross. You are getting these other thing, shift on the gross. So it is, I think, something that is not proper. But then, according to the Supreme Court, you can't take that to court. It's a policy decision of the government. You can only ask the Gen Z to go and supervise legislation so that it doesn't get legislated. So that's where we are. But the issue of structural interdict, for me, is a tragedy.
Right.
It's a complete tragedy, and it's a tragedy because of public interest litigant. It's going to make nonsense of public interest litigation. Because by public interest litigation, the anchor was Article 2, Clause 4, where anything done in violation of the Constitution was null and void, ab initio. Now, the courts are importing jurisdictions from areas like Canada, areas like South Africa, which don't have the same constitution as ours, and subjecting us to those jurisdictions. So, in the sense that now the Supreme Court thinks it has power to live outside the Constitution and above the Constitution, and even amend the Constitution in its judgments, which I think is an area that we need to discuss, whether a judgment of the court can amend the Constitution as it is.
Interesting. So for you, the last one, Wakili, 7 judges have decided that 3 judges of the Court of Appeal were wrong. What does that mean in the profession? Is it that the judges of appeal are not up to the standard required? What does it mean? Moving
no,
forward.
Sam, let me make it clear. Our legal system recognizes that judges have a right to be wrong, so long as they are wrong in good faith. And so the whole idea of the appellate mechanism from High Court to Court of Appeal to Supreme Court, sometimes you even start at the magistrates' courts or at tribunal, is that we recognize that a judicial officer or a judge can be wrong, and a person has a right to appeal to get a second look at the issue by another judicial officer. That's number one. Number two, the fact that I sit in a higher court doesn't mean I am more brilliant, doesn't mean I am wiser than a judge in a different court. It just means that I've been given a different function to review the decision of this other judge. There is a famous English judge, I think it was Lord Denning, who said that the judge, the decision of the Supreme Court is not final because it is right. It is right because it is final. What does this mean? That because they are the final decision maker, their decision is vested with rightness just because they were the last one to make the decision. It is not that it became final because it was right. You understand what I mean?
Right.
So the fact that our constitutional structure has put the Supreme Court as the final court, when they make a decision, we treat that as the right decision, even if you may disagree with it. And so for us as people who engage in litigation in the courts, like lawyers, one of the tools, one of the skills we have to develop is the ability to know when to say enough. I have done my best, but my best has not succeeded. I need to accept. So that ability, that it calls for some humility to accept that I may disagree with this decision,
right,
but let me just accept this is now the final decision.
Okay.
That is part of our structure of the courts.
Right.
So whenever you find a decision of the Court of Appeal or High Court has been overturned, don't use it to automatically say this judge maybe was incompetent. No, they viewed things differently, but the Supreme Court is given the right to have the last word on an issue.
And I think that will be the final for now.
On my side, I'll also say that...
You're already given your final position.
No, what Charles has said is very important.
Yeah.
That the decision of the Supreme Court is right just because it's the final decision.
Okay.
And for good order, we live by it and accept to move forward and continue developing jurisprudence to a point whereby we shall all be understood, and maybe the life that we seek in this constitution will be fully breathed into it.
Okay.
It's given the alternatives, I think it's an easier problem to deal with.
Okay.
It's an easier problem to deal with, especially for those who are not taxpayers.
All right. Thank you, Senator, for maintaining your restraint. And we have to leave it at that. Of course, there are so many pending issues in courts, very serious, including what was happening at the High Court today, and you'll be getting a decision or a ruling tomorrow.